Good morning, Chattanooga. This is Jim McKoon with Legal Bytes, and I'm here with Trevor Athcley, and we'll spend the next hour discussing legal issues that can affect your life, your business, your families. And Trevor, over the past several months, we've been holding this show, and we've tried to always talk about something specific, a specific topic, and spend the show trying to cover those areas. But I wanted to do something a little different today because we keep running into client situations where really, if they just with a little bit of forethought or a little bit of planning, they could have avoided needing us.
Yes, that's actually very common.
Yeah, very common. And so I thought that what we'd spend today doing is talking about these areas of mistakes that could be avoided. And while, you may have to spend a little money on the front end, it's a huge savings for what you'd have to spend on the back end. And that's true. We do that medically. I mean, you see the billboards about colonoscopies and how they can avoid, early detection can avoid cancer. Women do it with mammograms and all sorts of other testing. It's something that we do in our regular lives, but when it comes down to legal concerns or legal issues, people just blow right by them and don't understand, the risks that they're taking and how those risks could be very simply avoided, and with a de minimis amount of money if they would just do it.
Well, right, and that's all. I think you mentioned the medical community, and that's oftentimes when you hear anyone talking about a proactive sort of approach to resolving problems, it's often referred to as the medical model. And for good reason. The idea is we want to have some type of preventative medicine in the medical model. And likewise here in managing risk, we want to have a proactive preventative approach so that we avoid these very complicated and unfortunately extremely expensive problems which can result from not planning appropriately.
Right. And we run into these kind of issues in everyday life, and people don't seem to see them. For example, something with the changes that have happened in our families in America and with divorce and remarriage, taking a situation of a second marriage where there are prior children. We run into that every day. And, you run into the issue of, if husband dies and leaves wife, and husband has children from a prior marriage, and he hasn't done any type of estate planning, then when he passes, his children from the prior marriage may or may not receive anything because it's really left to the bounty of his surviving spouse at that point in time.
Well, if he died without a will,
right,
his surviving spouse would be an heir at law along with his children. Right. But that may not have been his intention. He may have intended for whatever he brought into the marriage to pass to his children, as right. opposed to his then surviving spouse. And those are issues which can be addressed before the marriage and some sort of prenuptial agreement. They also can be addressed after the marriage has been consummated, and you can have a situation where both spouses will come in and each will waive their right to an elective share or other spousal rights, where both spouses have a joint estate plan where they're benefiting their children from their respective prior marriages.
Right. And they use the term a prenuptial agreement or antenuptial agreement, and most people, that's an ugly word. That means that you don't think the marriage is going to work, and so you're pre-planning before you get married for a divorce that's going to happen later. And that's not always the case. I mean, we're talking about using a prenuptial in this situation to do planning to provide for a separate estate to be carved out for that husband or wife's children from a prior marriage, because we all agree at that point in time that we want those things to go to those children, whether they're minors or whether they're adults. I mean, there may be heirlooms, there may be some gifted estate. The wife may have some inheritance that she received from her father, and that she wants whatever is left of that when she passes to go to her children, etc.
Absolutely. And that situation is very common where you have two individuals whose first spouse died and they have children, and now they're remarrying. And so both spouses would think they're almost appalled at the suggestion that they might want to consider having a prenuptial agreement. But looking at it this way and talking about how, no, we're talking about just property issues, because when you get married, your status changes and who's going to inherit from you changes. And we need to address all these issues on the front end and have a clear understanding of what your intent is as to that you want your respective children to benefit from your respective estates.
Okay. Now let's talk about a different situation. Let's say that young man and woman are married, they have minor children, and for whatever reason, the marriage just doesn't make it and they get divorced. And let's say that the husband intends, or the former husband intends, that whatever he has, he wants his children to receive it and the like, and it would do that way as a matter of law. But if he doesn't have a will, who's going to oversee what those minor children receive?
Their parent, the natural guardian.
Right, which will be the ex-wife who he didn't trust in the first instance to stay in a marriage with. And yet when he passes, she's going to be the person who receives title or control over everything that he wants to go to his minor children.
That's correct.
And so, that's the common mistake we see, because if we don't do something for that, in this scenario we're talking about, for that husband who's recently divorced, to plan for those minor children and to make sure that they receive it through a will, through a trust, inside the will, through a fiduciary, that's going to be appointed in his estate documents over the children's inheritance. Then, otherwise, his ex-wife, who he may have divorced her because she was a spendthrift, he couldn't trust her with things or whatever, is now going to have control over.
That's correct. And that, in the case of a guardianship, that would be subject to some court supervision, probably. But you're right. That's the very person that the husband probably would not want entrusted with his children's money will be the person entrusted with the money. So it's something that clients definitely need to look at.
Could be the family farm. It just depends on what he's
correct. Saying. Even real property. That's right. And so it's something definitely that going through a divorce you need to consider, and then plan for it accordingly once the divorce is finalized.
Right. That's, so many times we have people, they've just gone through a divorce. They've gone through legal expense that they really didn't want to bear. It's been very tough. Divorce financially is tough on all parties. And when you sit down and you try to suggest to them that they need to do estate planning, oh yeah, we'll get back to you. And they just don't.
Well, and this carries over to beneficiary designations on retirement plans. Often the account owner has the former spouse still named as a beneficiary and would be appalled to know that upon their death, this ex-wife may receive that account because they were named in the beneficiary on it. And so those are all things that need to be addressed during the divorce and then planned for once the divorce is finalized.
Absolutely agree. I mean, it's much like, and you mentioned to me as we were coming over here to the station today, it's like the old Fram oil filter commercials. You can pay me now or you can pay me later. If you don't want to incur a minimum amount of maintenance fees, basically, to maintain your estate and take steps to protect it and what's going to happen to it, at your passing, it's either going to be very expensive to try to establish that that was not your donative intent or that was not your plan and that there was some error was made, or it's just going to be lost.
That's absolutely correct. And ultimately, of course, here you're in that hypothetical, the husband's deceased, so the children or somebody operating on their behalf will ultimately have to bear that expense. And so either way, it's going to take away from what they would inherit.
Right. So, and you're looking at spending many thousands of dollars in an estate dispute at some point in time down the road, where you could have probably handled all this for $1,000 or so in just doing some minimal document preparation and planning.
That's correct.
So, that's a couple of areas, at least because of the changes we've seen in divorce and remarriage and the things that are happening in our society that people just are not addressing, and it needs to be addressed. Another is the failure to plan at all. For example, we've talked before on the show about the need for a power of attorney.
That's right. And this I can't tell you how common this problem is. I probably see it in 8 out of 10 conservatorship actions, where if the respondent, the person that needs to have a court-appointed fiduciary, had some instrument in place for planning for a power of attorney or some type of whether to manage a person or over the property, whether it was a trustee or some type of fiduciary, if that had been in place, then there would be no need for the appointment of a conservator. But when those instruments are not in place, then we get into situations where someone actually has to ask the court to intervene and to appoint a conservator, and that is a major expense that is often incurred and is unnecessary.
Well, it also results in a lot of hurt feelings, because then your loved one is being brought before the chancery court, and they feel like you're trying to say that they're insane or they're incompetent. And truly, the standard law is just you've got a disability that needs assistance, and we're trying to address that under the only legal means possible, because you didn't provide us with a power of attorney
at that point in time. Right, that's the last available option.
Right, exactly. And so, if we could do nothing else to the listeners out there, is urge you to, in reviewing where you are in your life and the things that you may have and the objects of your affection, to at least consider setting up powers of attorney, a durable power of attorney that will survive your incompetency or issues. You may want it to be what's called springing, where it doesn't even come into effect until you're incompetent and declared by a doctor to have that issue. Some people like that for better control.
They do, and a lot of those springing provisions require 2 physicians to opine. So there's added protection in there. Very often, people that prefer the springing provision are very self-reliant, very autonomous, and they don't want somebody to act on their behalf unless it's absolutely necessary. And that springing provision provides that protection.
Right. And other people, though, would want one that's just in effect immediately upon signing it. Maybe you want your wife because, one, you want it there if there's an incompetency, so you do want it durable. But it may be that you travel a good bit, and as a result of business or the like, and that you need things handled back home. And so you can have those things handled by whoever's holding your power of attorney. It doesn't have to be a spouse. It can be a business partner.
Any correct. But it's somebody in whom you need to have the utmost confidence and trust.
I know we've closed several real estate transactions recently where we had a POA in place. Now, we did need to make sure it was filed of record, because the title company wanted to see it and wanted to make sure everything was done. But we were able to transact the business and get the closings done, even though we had people of record not available for the closing.
And one, I guess, downside to the springing power of attorney is that because the authority is not effective immediately, sometimes the agent's authority is their ability to act is delayed in the time it takes to procure those statements from the physicians. But ultimately, though, you want the person who signs the power of attorney to be comfortable with the authority they're granting. And if they don't want the authority effective immediately, that's the legal means to accomplish that objective.
Right. And I mean, from the standpoint of pure expense, I know we do a lot of these for people, and I know you're involved a lot in our firm doing those. We're not looking at much money for a power of attorney.
Oh, no, not much at all. It's normally done in a package, where you do healthcare, general business, durable power of attorney, a living will, and then a last will and testament. And for real simple forms like that, you're probably, assuming it is simple, you're probably looking at somewhere around $500.
Right, to have your whole package put together. And so, we have to urge you, and those rates are, they're not across the board, but those are fairly standard for a lot of the firms that do this in Chattanooga. So please consider making these plans for you, the listener, so that you can avoid these issues, because truly they cause a great burden on you and on the family later if they're not addressed. And if any of you have any questions about that, please give us a call. Our number here at the station is 423-800-8949. Or you could call Trevor or myself at our office. Our number at the office is 423-756-6400. I know, Trevor, you're doing this almost every day. You've got these kind of issues coming up.
That's true, and we see it I mean, I can't even tell you how frequently we see it. It happens on it's such a common occurrence that it's almost on a daily basis. We see something like this where if people had planned in advance, we'd be avoiding a major problem.
And, so many people think that, well, if I titled the property that I've got correctly, that'll address the issues, and it just simply doesn't. That will go a long way if you've got things set up in tenancies where, your spouse can take over or something happens or whatever, or she's got rights equal to yours. But that's just not sufficient to address all the myriad of issues that arise on a day-to-day basis, especially if you're a business owner. So, we need to address those.
Well, and sometimes people will, that's a great example. They'll have a bank account titled Joint Tenants Right of Survivorship or a payable on death beneficiary designation. And the account owner, the parent in this instance, will often instruct the person receiving the property, you're named on this, but I intend for you to share it with your brothers and sisters. But there's nothing in writing setting out exactly those restrictions and stipulations. And then when the account owner dies and the surviving tenant or the surviving payable on death beneficiary receive full title to that account, and then there's a question of if they don't voluntarily follow through on what they were instructed from their parents, there's a question, how do we enforce that?
Right.
If it's not in writing.
Right, exactly. And going back to the POA or the power of attorney, and especially of a durable nature, a lot of times when we get to healthcare issues and the fact that we've got, a very independent, sometimes obstinate individual who has gotten into some form of dementia and needs perhaps a level of care where they just can't live alone. If you don't have a power of attorney that authorizes you to take steps to access medical records, to perhaps try to contract to enroll them into an assisted living facility or the like, then you're left with nothing else other than a conservatorship action.
That's correct. And that it's just for the listeners out there, typical conservatorship action will involve at least 2 attorneys, possibly 3. And you could be looking at a situation where just the expense to get a conservatorship established can cost anywhere between $6,000 to $10,000.
Right.
That's obviously a significant expense.
Right, because what the court does is they charge a lot of the expenses that are awarded to the ward's estate.
That's correct.
So, if it's your daddy that you're trying to take care of, and because ample planning wasn't done when he was competent, then you've got to incur this, and there'll be a guardian ad litem perhaps appointed. There'll be an attorney for the petitioner.
If he requests one, that's correct.
Right. There'll be so you look at multiple expenses being incurred.
Possibly an attorney for the respondent if he asks for one. So you probably in all cases it's almost always 2 attorneys involved. In some cases there's 3, and obviously the attorneys are appointed by the court to do something important, and they have to go out and do their job, and there's significant expense incurred in that.
Right. And so all those things could be avoided by simple power of attorney in most instances, as long as it has the proper provisions, as we said, being durable so that it would survive the incompetency of the individual or disability of the individual. And if it's got a springing provision that you've got a physician or physicians, depending how many opinions are required, that can opine and write in a letter that their condition is justifying the power of attorney's actions.
That's correct. And that it's a lot of people have the mentality of, I know I need that, I'll get around to doing it. But some of these, particularly with healthcare power of attorney, some of the conditions happen, due to a car accident, some unexpected accident where the person's rendered incompetent and unable to manage their business affairs or their medical affairs. And so it's important for people to realize I'll do it later was not the best way to look at that.
Right. And what, the listener needs to understand is that the downside and the benefit of the power of attorney is that it can be revoked. So let's say that, you are concerned, you need a power of attorney, but you're concerned about perhaps the person or your options as far as giving the power of attorney. You can go ahead and execute one with the best option you've got at this point in time so that you've got the issues addressed as best you can. And if that option turns out to be not someone that you really want to stay in control because relationships change or facts change, then you can always revoke that power of attorney and grant another one. As you haven't put anything in stone, all you've done is try to protect your interest as best you could at that point in time.
And assuming you're competent to revoke it.
Right.
Correct.
Right.
Yes, you always have the power to revoke.
So, I made that assumption that, you're still there. And the reason why that's the downside is for the person who's got the attorney position and is trying to protect you or take steps for you and believes that you're not competent. Then if you try to take steps to revoke it, then you throw everyone into a quagmire of, is it revoked or not? Did you have the authority to revoke it? Are you mentally competent to do that? And that may throw us right into a conservatorship anyway.
That's correct, because then third parties will be very reluctant to rely on the agent's authority where you have a question of whether or not the principal has revoked the agent's authority.
Right, exactly. So, again, we got into this from the standpoint of mistakes that could avoid major expense, especially to your family, legal monies that would not necessarily be needed. Again, back to the Fram oil filter, you can pay me now or you can pay me later. And it's pay me now a small amount, and the planning and maintenance is like anything else. It's like your home. If you don't maintain your home, you get major issues that cost a lot more. It's the same thing on the legal side. If you can do some just minimal planning that's relatively inexpensive, you can avoid major issues later down the road. And so that's what we're trying to help you do. Now, you've run into issues. I've been raising all the suggested areas, but I know you run into them in your practice, Trevor.
Oh, very frequently.
What's another area that you see mistakes?
So we often see it when you're looking at whether to do a probate of a decedent's estate. And somebody will come in and they'll say, my mom talked to me about having made a will, but we can't find it. Lo and behold, mother never made a will. And so you run into the issue of not proper estate planning. And that happens both with where a person either never made a will or made a will, but they never changed it as circumstances changed in their lives. And I actually have an estate now where at the time she made the will, the family circumstances were one way, but then when she passed away, things have changed dramatically, but we still have that original will in place. And it's causing a great amount of family conflict and consternation because as circumstances has changed and certain children were benefited during her lifetime, but the will was never updated.
Okay. So that's the mistake that is made, is the failure to keep your estate planning documents living with you. Because life changes, so do your documents. They need to change.
Absolutely correct. Yes.
Well, we're down to the first half hour. We'll be talking about more mistakes that can be avoided on the second half hour. We appreciate you tuning in with us, and we'll be talking to you in just a few minutes.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Day 2, Carol Gaddy, 69 years old, held as a political prisoner in Sequatchie County. She refused to allow an illegal search of her home. It's official. David Roddy, the new chief of Chattanooga Police. The city council voted 8-1 to approve him. Russell Gilbert casting the only no vote. Councilwoman Demetrius Coonrod asked that he be given a chance, saying the council could hold him accountable if there were any problems. Russell Gilbert telling Roddy to his face that he voted no, but he hopes he's proven wrong. The girlfriend, William Howard Wright, testified on Tuesday in court that Wright, who's accused in a homicide case, drove 2 men in her PT Cruiser, and those 2 men later disappeared and were found dead in a cemetery in Chattanooga. She said a 17-year-old man who accompanied them had blood on his shoes when they returned. The bodies of Rayshawn Underwood and Thomas Holder were both found by former city councilman Manny Rico, apparently shot to death in a cemetery. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
AM 1240 and 92.7 FM's fast forecast, now. 77 degrees and cooler to start out our morning, getting up to 88 today for our high. A very light possibility of thunderstorms as we reach the end of our day for our evening. Temperatures getting back down into the 70s overnight. Overall, a very cool day today. Tomorrow, temperatures dipping down even further with 87 for the high and a possibility of thunderstorms starting up over the weekend on Saturday. That's your fast forecast now.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
You've been in a wreck.
756-6400.
You've been wrongfully fired.
756-6400.
A turkey is suing you out of the blue.
756-6400.
Confused about a business startup?
756-6400.
That's the number for you. 756-6400. Right here, right now, Chattanooga. Call now. Top flight legal help awaits. Get biz advice now. Representation to fight for your right. What are you waiting for? That's 756-6400. Don't sit on your rights. You've got remedies. Turn your tragedy into cash. You've got the solution from estate planning all the way to probate. Act now. Top attorneys in Chattanooga are waiting to help you get relief. Act now. No out of pocket. You don't pay a dime until we win, so win with us.
756-6400.
Call now. Top flight legal help awaits. What are you waiting for? That's 756-6400. Turn your tragedy into cash. Act now. No out of pocket. You don't pay a dime until we win, so win with us.
756-6400.
756-6400.
You used to call me on my cell phone.
When you crack your screen, mess up your charge port, you get soaked in a rainstorm, what do? Save money, save big. Fix it. Get surgery. There's a cell phone hospital near you. It's the Cell Surgeon. Adam Disbrow, the man in white, he replaces your screen, fixes your buttons, gives you back Twitter, Facebook, your online universe. Walk-in patients go to Cell Surgeon in Ottawa. Cell Surgeon is new in Ottawa, next to Zaxby's. Other docs in the cell repair business are just lab coats. The doc at Cell Surgeon is the best. He wants you to be happy. Fix your phone, save money, and save time. Every minute is valuable, and Cell Surgeon doesn't want to waste a second. Your wireless MD, the Cell Surgeon, quick and precise with your device. Takes an hour or less. Northgate Mall, Cell Surgeon next to Old Chicago Pizza, 900-8263, thecellsurgeon.com. Like him on Facebook.
You used to call me on my. You used to.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Welcome back, Chattanooga, to Legal Bytes. We've been talking during the first half hour, and we'll continue now about common mistakes that, if they could just simply be avoided, could avoid major legal expense and frustration of plans or interests of each of you out there and what's happening in your lives. And we've talked about how second marriages and divorce can have major effects that can be addressed and avoided. We've also talked about, the failure to have a power of attorney in place, a durable power, whether it's springing or non-springing, and the problems that can cause, and that can even result in a conservatorship if necessary. And we talked about how to avoid those. And we also talked about how we can address healthcare issues if we've got a power of attorney in place and try to avoid the conservatorship. But I know that there are a lot of other problems that come up, and one of those that I've run into a lot of times is the trusted employee. I know all of us, especially those of us in a what you would consider a small business, at least on federal standards, where you've got a couple of central employees that you rely on a lot, and maybe that employee is in some type of administrative capacity where they're handling some of the company's finances. Often that results in a major problem. And it's not just small business. And I've been involved in a lot of credit union litigation where there have been people that are handling funds in a rather large facility that have had problems, and banks have those issues. The hospitals have those issues. So it's not small, but I think more along the lines of the trusted employee and with the small business owner. And, he has put her in a capacity because she's successful as an employee. She has been there for a number of years. She's been with the growth of the business, and they build a relationship that he puts her maybe in charge of handling all the customer payments and putting together the deposits. And especially in a situation where we're talking about a business that does some cash. People may not be bad when they get into those roles, but because of stresses of life or changes in that trusted employee's life, you're now exposed to that trusted employee, perhaps embezzling funds, taking funds, doing things that maybe they wouldn't ordinarily have done. And maybe they don't even intend. They think they're just borrowing initially. I know from the years we've done these in the past that oftentimes they think I'll just borrow a little bit and I'll put it back next payday. And it became so easy. And there was a little bit more and a little bit more until the amount is, they can't. And so then then all of a sudden they don't even want to go on vacation because they don't even want into the books and records to see where they're hiding the problem money and the like.
And so that's where I think, run into the solution to that problem with the trusted employee is having some type of check, whether it's an annual audit or whether it's a monthly review of the accounts and deposits and withdrawals.
I agree with those things, but I think it's even simpler to just splitting the responsibilities in the business. I don't care how trusted that person is. I don't care what kind of relations you've had. Divide the responsibilities. If one person is receiving the funds, they'll make a report of what they've been receiving, and another person is depositing, and they'll prepare a deposit report. If that collection report and that deposit report don't match, one of the two has done something with the funds.
And it could be something as simple as there was an error in arithmetic. But
sure,
you got to reconcile those figures.
But you'll do that on a daily or weekly basis. You won't, months or years down the road determine that you've got a problem.
And that's often what happens is people don't realize the problem exists until such a glaring hole there in your accounting that you think, what is going on here? And you go back and check the books and you see all the problems.
Right. And so, just simply the mistake made is the failure to put in checks and balances, put in some form of audit or checking basis where you, the business owner, can verify that what you're seeing is actually what's happening. And if you'll do that, then you can avoid the expense of hiring the attorneys later in the day when an embezzlement occurs or there's a clear loss and you haven't been able to check it until it's quite sizable. And it's a real drain on the business, both from the standpoint of the loss of revenues, but also from the standpoint of the legal fees that you're going to incur in either prosecuting the individual criminally or civilly, and or prosecuting an insurance claim, because there are insurance policies out there with your normal business packages for employee theft or fidelity loss that can be asserted, but they require some type of audit expense as well as legal expense to even put together the information necessary to establish the claim.
And that's if people could see how much expenses incurred on the back end trying to solve the problems versus the expense incurred when you proactively address the issue, on paper, it's a no-brainer. The problem is that people often have the mentality, this is not going to happen to me, or, I trust this person, he or she would never embezzle money or steal from us. But we see it so often, and it may be we are a little cynical, but, you develop that cynicism over time because you see all these things that occur. And so you can advise your clients and all of our listeners, you're much better off addressing this on the front end and having these procedures in place. And there may be some duplication, but duplication is necessary to prevent a huge loss from occurring.
Right. And, if you're the person as the business owner that has to end up reviewing the stuff at night or over the weekends, you're working for yourself. It's you're trying to take care of yourself. And if, I know a lot of us are tired and we get a little lazy and we just don't want to do that, but that's the mistake that's made, because the devil's in the detail, as we always hear. And truly, you're not going to find, a $10,000 dough ball, as we call it in South Georgia, go out the door. You're going to see $600 here, $300 there, $150 here. And if you're not watching for these numbers, then, you're soon going to find yourself in a bad situation. And we see it all the time. I mean, seriously, we're involved in an embezzlement or fidelity fraud case on quite a regular basis in our office. And it's simply because of, on most situations, because checks and balances weren't in place. Now, there are sometimes, because, thieves are good. And there are times where the things that they carry out is just a manipulation of what was a good process in place, but it still got manipulated. I've seen a chief financial officer do that, where she was able to go out the door with $1.2 million. And there was an annual audit being done every year by an outside accounting firm. And she was able to manipulate the information where the auditors weren't even catching it, which was amazing.
That's a rare occurrence, though, where somebody's that sophisticated.
So that's what I'm saying. There are people that are really good at what they're doing if they want to carry out a theft. So it's not always a mistake, by you, the owner. But truly, most of these situations can be avoided simply by putting in checks and balances, divergence of responsibilities among employees, so that, you don't have one person doing it. And by dividing it up, they would have to literally work in concert to be able to pull off a theft or a fraud.
Which is not outside the realm of possibility, but just having that one extra layer of protection makes it much more unlikely for that to happen.
Absolutely.
And Jim, we were talking about our topic for today. I had written down a note, and I just said due diligence. And
yes,
a lot of times people think of due diligence in the context of major business acquisitions, and they're making sure that what a business's profitability is what the transferring company says it is, or something to that effect. But even on this much smaller level, whether it's the trusted employee, whether it's making sure you have your estate planning documents in place, that due diligence is really what we're talking about, is just planning in advance for what could occur in the future.
Right. And it goes to all sorts of realms. For example, home buying. If you're going to buy a home, you will get initial disclosures, at least in this area by law. You'll get an initial disclosure of any changes, improvements, problems that the home has had in the past. And based upon that disclosure, you've got some information, but don't just rely on the disclosure. You hire a home inspection company and have someone who's professionally licensed and bonded go in and check and determine whether or not the house is as you anticipated. And then on top of that, what you may want to do is you may want to go behind that inspector and determine whether or not the home inspector has done their job. I know of a situation here in Hamilton County where the home inspector missed an area, and the buyer went in immediately behind the home inspector and found the problem. Unfortunately, it was after the closing, but the home inspector now is dealing with the problems that were missed, and you've got another layer of protection for you as the home buyer by doing the due diligence that's necessary to protect your own personal interests.
And it's entirely possible, you're talking about the notifications that the seller is required to provide the buyer. In some of these cases, it's totally possible that the seller wasn't aware of the problem. In other cases, the seller may have misrepresented facts in those disclosures. But once you've already closed the deal, you're looking at major expense trying to correct it. Where if you caught the problem in advance, you'd be able to say, well, we're not closing on this transaction.
Right, exactly. So, I mean, again, we're covering simple steps that if those mistakes are avoided by you, the individual, you can avoid major expense on the back end from the standpoint of what it would cost to address, to repair or correct or avoid the damages that could be caused.
And then in the context of a real estate purchase and sale agreement, if those issues are discovered, all that becomes part of the negotiation with the seller. The buyer says, I've got to make these repairs. It's going to cost this much money. We either need to have the seller pay for it in advance, or we've got to reduce the purchase price in order to make these repairs after we close the sale.
Right. And, and the way you structure that, and again, the agents necessarily be involved, and you may need counsel involved depending on how major the problem is. The way you structure that can also help avoid warranty claims being your responsibility later. Like, for example, let's assume there's a problem with the roofing in a house that you want to buy, and you, the seller, want the sale to go through or willing to make certain accommodations, but you're not going to be responsible if whatever's done to that roof isn't sufficient. You don't want to be responsible a year later for a leak. So what you can do is you can structure it so that what you'll do is you'll cut a check or reduce the price of the sale and leave it to the homeowner to engage whoever they want to engage to make those repairs, so that you're out of the loop as a seller for any warranty claims or problems with what was done.
Absolutely. That's correct. Yes.
Yeah. You don't want to be involved in those kinds of issues. Let's see, from the standpoint of due diligence in your business deals, I mean, you've got to go into the accounting records and like, and so oftentimes people will come into me with a transaction where they've signed a contract and now they've realized that there's a problem and they had not looked at it or seen it before the contract was signed.
And if you plan appropriately, the contract itself may include a due diligence period.
Sure.
Where
but what they want to do is they want to claim now, well, there's a fraud. And oftentimes there wasn't a fraud. The document itself, the contract may provide that, that it would alleviate a fraud claim. But the pure problem is you didn't do your due diligence to find out what you were really buying. And so now you've bought a pig in a poke.
Right.
So, I mean, that's where, we've got, and you're not talking about major money compared to the transaction. I mean, oftentimes your due diligence price will in some respect be related to the size of the deal, because you got more involved, more assets to investigate, more books and records to go through, perhaps more employees to consider, and whether or not they're key employees you want to hire or not hire. I mean, there are a lot of issues out there, but my gosh, if the transaction's that large, you'd have to be foolish to go through the mistake of not doing all the due diligence would be adequate and appropriate.
Absolutely. And the risks are too great. Now you're not always going to catch every problem in your due diligence period, but it can give you your best shot of addressing all of those issues on the front end, as opposed to trying to deal with them after the fact, where you've lost all your negotiating power at that point. In fact, you have none as far as that transaction is concerned.
Exactly. And then from the standpoint of the old industrial properties, we have a lot of those in Chattanooga, and it's not just the industrial. Sometimes it's some of the residential because of what happened in years past here in Chattanooga. But you've got to do your environmental due diligence. And I've time and time again, even in today's age with the knowledge that's out there, I have seen buyers acquire property that had some type of contamination on them solely because they didn't do the preliminary investigations that were appropriate, reasonable and appropriate for the transaction.
And that's a great example. It also happens where a builder acquires property and wants to start construction and doesn't go through the proper steps with, our community development office, and they end up getting tied up in regulatory disputes with the city, where they didn't go in and they didn't do whatever necessary inspections required before they started constructing. And the land development office will shut down a project if the person hasn't gone through and gotten the proper permits and made sure they're in compliance with all the local regulations. And I've seen that happen on several occasions.
Yep, exactly. Exactly. So we've got the due diligence in acquiring the business, the due diligence in acquiring homes, just simple steps that so oftentimes people want to avoid. But, just by doing the necessary, reasonable, prudent steps, you can avoid major litigation or major legal issues and expense down the road. And again, it's the Fram oil filter, pay me now or pay me later, and you can save so much, if you don't go down there.
I hope Fielding's listening today, because the Fram oil filter illustration is one of his favorite examples.
Okay. Fielding actually.
Yeah, I've heard him mention that several times.
Yeah, well, that's because Fielding's old enough to remember that old ad.
That's right. And he always prefaces his example as, you remember the Fram oil filter commercials? And of course, all the young people in the room are shaking their heads and they have no idea, but his client, typically an older fellow, will know what he's talking about.
Right. I mean, and I'm not much younger than Fielding, so I do actually remember that. And I remember Hank Schramm doing all the STP commercials. I have a vivid memory of all those old shows when I was younger, and they were before you were even a glint in somebody's eye.
Probably so. Yeah.
Oh no, absolutely so. I'm beyond probable. Okay, so we got. Have you had other issues or problems that you've seen that clients could have avoided?
Absolutely. I mean, going back to estate planning, for example, where a client wants his wealth transfer mechanism to be by a trust, a living trust, revocable trust. They will set up the document and will provide for how their property to pass upon their death, and they'll have named a successor trustee and the successor beneficiaries. But the problem will be that they have not retitled all their assets in the name of the trust. And so the trust is not effective in transferring title to that property.
Right.
And so we now have totally defeated the purpose of the trust, which was, to be a very simple way of transferring title to assets upon the death of the settlor. We also run into situations where the person doesn't nominate successor trustees. They'll have one successor, but sometimes that person they've named in the document does not survive them, or is not physically able or willing to do it at that point in time. And so we always encourage clients to name at least 2 successor trustees, an alternate, in the event that the primary person is not available when their fiduciary authority would become effective.
All right. So when you, in that situation, just so that people see what they're fixing to run into if that happens by that simple mistake, if you have a trust that becomes effective, the trustor or settlor dies, and the trust is like effect, but you've got no trustee willing to serve or able to serve, what happens?
You have to petition the court and ask the court to appoint one.
Right. And so at that point in time, you'll normally have a banking institution,
or a local lawyer or a CPA or a banking institution, and anyone appointed at that point is going to have to charge a fee.
Right.
And it's going to be probably much higher than the person that they normally would have appointed to serve.
Right. I mean, your trustee that was appointed, that was maybe your buddy,
Right.
Your lifelong friend, if he would have served, he would either not charge, or he'd have charged some minimal charge for the amount of time he was having to put
Correct.
in to take care of bank accounts or property and the like that he was governing under the trust.
And in a lot of these instruments, the settlor will give a lot of discretion to the trustee in how to make distributions and how to benefit the beneficiaries. And the concept there is the person you've nominated to serve is the person who you trust and whose discretion you want to operate in actually distributing money from the trust. And if you have some stranger being appointed, you have no idea how that person would exercise their discretion.
Right. And, the trust department of a bank or some local attorney who doesn't know the family, is he willing to, use discretion and make decisions that could open him up for a claim and a lawsuit? I don't think so.
Absolutely correct. And so you're in some ways defeating the intent of the settlor by not having someone the settlor intended to be that person acting in that capacity.
So often what happens is just simply because you failed to appoint one more successor trustee, you've ended up with 1, additional expense on that trust, and 2, you've ended up with perhaps your intended loved ones that were going to be the benefit of that trust not receiving those benefits because there were no specific directions.
Correct. In exercise of the trustee's discretion.
Right. because people just don't want to do it. And I understand that. And in fact, if we were in that situation appointed, we'd be in a similar opinion.
Absolutely.
Because you open yourself up if there are multiple beneficiaries as well as generational beneficiaries, and you've done too much for one that because in your discretion you determine it was appropriate, the others will claim there was an abuse of discretion.
Absolutely, and they'll a breach of the fiduciary duty.
Right. So these are very simple things for you, the listeners, to consider in trying to avoid these problems. They're all minimal expense or time and effort on your part, but they will save. My mother used to call it bukus of money on the back end, either in legal fees or in loss or damage suffered, or in just general expense, because of the fact that you would have avoided these ramifications. And they're so simple. So we urge you to call your counsel, set up the time for your estate planning. We've talked about second marriages and children. We've talked about divorce with minor children. We talked about the need for a durable power of attorney. And again, you can do whatever you want to from the standpoint of springing or non-springing, but making sure that you've got yourself protected so your family can avoid a conservatorship if necessary. We've talked about having checks and balances in your businesses so that you can avoid possible losses because of trusted employees. Same with doing business with a trusted friend. What was it Reagan said? Trust but verify. Always document, even with a close friend in business. This is Legal Bytes. We'll talk to you next Wednesday. Thanks for joining us this week, and we hope it's been helpful.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights in future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time in your life.
WBLZ HD4 Ottawa, W224AZ Chattanooga, WSDT Sunny Daisy Chattanooga.
CBS News. I'm Steve Kaith, and there's new information on the health conditions of American diplomats who came home from Cuba amid suggestions they were targeted by sonic attacks. CBS's Steve Dorsey broke the story earlier this month. He joins us live now from Washington.
Steve, medical records show a U.S. doctor warned at least one diplomat of health risks to future exposures. The group of Americans and Canadians sought medical treatment after complaining about hearing loss, nausea, headaches, and trouble with their balance. The group visited American doctors throughout March and April, and one U.S. specialist visited Havana to assess U.S. embassy workers. A number of diplomats chose to cut short their assignments in Cuba. Cuba denies it has any involvement in what Secretary of State Rex Tillerson calls health attacks. Live in Washington, Steve Dorsey, CBS News.
To his back